It's time for Law in Our Life. That means we have Gwangju, a locally practicing lawyer, here in the studio. Hello, Gwangju.
Hi.
How you doing?
Good. How are you doing?
I'm all right. The summer's going by, and I'm excited. We're going to talk about some interesting stuff.
Yes.
Some interesting things about Korean law.
Right.
What have you got for us?
You may have seen prohibition of competition clause in your contract and may wonder the legality of those provisions.
Okay.
So today I'd like to talk about how to analyze those provisions.
Oh, yeah. I used to watch this TV show called Mad Men, and competition clauses came up in the show a lot. Because, the guy's like a big ad executive, but, the company doesn't want him leaving and going and working for some other people.
Right.
So they're always trying to get him to sign one of these. So tell me about it. How does it work?
According to the Employment Contract Act, an employee may not undertake work or someone else than the employer or engage in such activity if such work is likely to harm the employer during the contract. The law restricts all employees' competing actions, not only making employment contract with another employer. Prohibited competitive acts are, for example, making another employment agreement, undertaking work on one's own behalf on a part-time basis, setting up a business functioning on the same field as the employer, or obtaining an interest in such a business.
All right, that covers quite a few things.
Yes. After termination of the employment relationship, the employee may take employment in a competing business or set up a competing business, unless the employment contract provides for a prohibition of competition extending beyond the duration of employment relationship.
Right. I think this happens sometimes in jobs that have proprietary information.
Yes.
Right? Or, I don't know. What are some jobs do you think that are affected by this?
Most of the jobs are jobs that are dealing with more business secrets, something like an IT developer, and then if you leave with all the information and go to the competing company and just utilize that information or that newly developed techniques.
Right. Yeah, I think there's a big case going on sort of with this. Like it happens in tech industries like with, if I worked for AI with Google, I can't go get a job with Uber.
No.
And start sharing these ideas with them. All right. Now, this is different from the visas that some foreigners have that says that we're not allowed to work for somebody else, right?
Yes, that is more for like immigration purpose to kind of like regulate the activity of the foreigners, because the visa is given for a specific purpose, and when the visa was issued, the officer might have not thought that the foreigner is working on other fields.
Yeah.
So that's a different thing, but it's more of an like employment issue.
Yeah. But I know this does apply at a lot of educational jobs. For example, my job, I'm not allowed to go work at a hagwon.
No.
Even during vacation, I'm not supposed to go, I don't know, like do some English camps and make a bunch of money up in Seoul or something like that. Not that I would. I'm down here. Now, are they legal? There's some questions about this. Can they tell us what to do with our time outside of work?
Yeah. Okay. But they cannot like extremely restrict your activities.
Okay.
The Korean Supreme Court found that even though there is a prohibition of competition clause in the employment contract regulating the activities of the employee after the term is over, the provision is void as a violation of Civil Act Article 103 if such provision excessively restricts the freedom of job choice and work rights that are protected under Constitution, or excessively limit the free competition.
All right. So maybe if I was a foreigner and for some reason my hagwon tried to make me sign a contract that said if I left their hagwon, I couldn't teach at another one.
That would forever?
Yeah. Or even for some period of years. That would be excessive, right? Because that's the only kind of job I can get here as a foreigner.
Yeah.
I feel like that would be too restrictive.
Yes, I've not thought of like from a foreigner's perspective, but I agree.
All right.
Yes.
All right. Now, how can we look at a competition clause like this and kind of figure out if it's fair?
To decide the legality of prohibition of competition clause, one should look at the following factors to decide whether there is first, employer's interest that should be protected. Second, the position of the employees before resignation. Third, the period, location, business of prohibition. Fourth, any compensation to the employee in return of such prohibition. Fifth, the reason employee left the job. And lastly, public interest and relevant conditions.
Okay. So if I break a non-competition clause, they can sue me.
Yes.
I would assume, right?
Yes.
Can they make me quit the job?
Sometimes they can file a temporary restraint, kind of like not a restraining order, but temporary order to like prohibit you from working.
Okay. Wow.
Sometimes, it's usually for entertainers.
Okay.
So
all right.
yeah,
so
if
you
they
quit a network or something,
and then started working for another agency, then if they're saying, oh, it's not done yet, you should work with us, or you cannot start working with them, then they put a kind of like temporary restraining order from them to prevent from participating in a new business.
This stuff happens in the music industry, I think. I think that's why Prince had to change his name to a symbol so that he could still release music. Okay. So that number one, the employer's interest has to be protected. That's important, right?
Yes. The employer's interest that should be protected includes the knowledge or the information that the employer has, such as know-how, even though it does not reach to the level of business secret, which the employer and the employee agreed not to reveal to the third parties, like client relationship, goodwill, or reputation of business.
Okay.
Let's think about an English teacher.
Oh, great. I like examples.
Yes. An English teacher left the hagwon and started his own business. The new hagwon was located 2.2 kilometers away from the previous hagwon and was open only a month after the resignation.
Okay.
In this case, the prohibition clause was the instructor cannot open the same kind of business or work as instructor for 12 months from the date of resignation or termination.
Wow.
The location should be at least 5 kilometers away from the hagwon. The hagwon filed a lawsuit against the teacher and claimed the agreed damage award as they had penalty clause as well.
Okay.
The court found that the clause is void.
Woohoo! As the foreigner.
Yeah, they considered the following factors. The initial employment term was 1 year, and the 1-year prohibition term is unfairly burdensome.
Yeah.
And there was no compensation to the instructor in return of such prohibition clause. So sometimes they give more money in return of including those prohibition clause, but in this case there was none.
Okay.
The know-how of hagwon is not likely to affect the student's choice of hagwon. So like he got nothing from the hagwon's like reputation.
Right.
No interest to be protected on the employer side. And lastly, no impairment of public interest in this case.
Right, because competition is good, right, for the free market. And so they're probably not going to try and restrict that too much. Okay.
Therefore, the penalty clause became void as well.
All right. This is a real case?
Yes, it's actually from the Gwangju District Court.
It happened here?
Yes, and it was made in 2017.
Oh, it's pretty recent.
Yes.
I'd kind of like to ask around and find out who that was. All right. So there are ways out of these if they seem a bit unfair.
When you make a contract, you should be careful about the prohibition of competition clause. But if, as the case law says, there is way out by making it void through the court fighting. Yeah.
I've heard stories of people, that had hagwons and had people leave them. And then that person opened a very similar hagwon, very close by, with very similar textbooks and curriculums and everything. And I'm sure it must be very frustrating because it's such a high competition business. Yeah. But it's hard to restrict it, right?
But if you just if you worked for a kind of franchise hagwon and then you followed their patterns, like applied or adopted their curriculums and everything, then it might be a different issue, I guess,
Oh.
because then you are using their know-how
Okay.
or like their unique
Mm.
curriculums.
All right. So,
So
Fair
yeah, you
enough.
should be careful, I guess.
all right. Well, I'm not going to be. I don't need to worry. I'm not going to open any hard ones. Now, thank you so much. This is, of course, online as well, right?
Sure. You can find the segment in video and my YouTube channel. You can find me by searching Korean Law 101 on YouTube.
Thank you, Gwangju.
Thank you for having me.
Okay.
Yeah.